Good afternoon, everyone. Charles Tassel, COO for National RIA, and focus on the legislative issues here. Have two guests with us today, both Jeff Watson and Jeff Greenberger. Both are experienced attorneys and litigators on issues related to real estate. And for our purposes today, especially with regard to eviction issues. As many of you are aware, the reason for this call is the issue of the CDC following up on what was originally an executive order saying the CDC has the right to step in on evictions or step in and ban evictions. And the CDC weighed in officially today with a nationwide ban on evictions for non-payment if they are COVID related through December 31st of this year. The impact of that at this point is unknown. The term I was just using was just on a national interview, and the discussion was this is devastating and could have devastating consequences to our economy, to our housing stability, is absolutely going to afford housing affordability. And there will be, at this point, unknown number of properties going into foreclosure, even as we come up with what looks like a wave of evictions, most likely, right at New Year's, and one of the worst times. And that's assuming that it doesn't get extended, which, let's face it, folks, it will probably be extended at that point. So we do not see an end in some sense. This is one of these things that we have been stepping out on this. We have spoke out on it before it came official, which was today. We started reaching out. Laura, if you'd share the voter voice legislative action, which actually goes to the president, the vice president, secretary of HHS, as well as your representative and your senators, to let them know that this is a problem. That being said, until this is actually in court for constitutionality, and again, I'm not an attorney, we're not giving legal advice here, even though the other two are attorneys. This has gone from what has been, from a federal perspective, a good move in May and June, which was a transition from feds handling everything back to states, even to local levels, not only state by state, but county by county responses to, again, taking it all back at the federal level and addressing it there. In the voter voice, in the letter, we actually suggest a couple of common sense solutions. Thank you, Mr. Watson, for those ideas on that as well. Again, a way to focus this to, if there's a COVID positive patient and they're one of your residents, I don't know too many property owners who go, no, I'm good, let them sit there for a little while. I'm okay with that, because let's face it, I'm not going to be running in there right off the bat either. If there's an area that's got a high infection rate and everything is shut down, chances are the courts are already shut down. We've seen that across the country in different areas. But to just ban this across the board does not make sense. To that end, we've got copies of the declarations that are out today. I don't know if you're aware of this, but legal aid societies are actually sharing this out and telling people they couldn't sign until today. My pushback on them immediately was, why could they sign it today if they're supposed to, according to this document, do their utmost? They're supposed to be due diligence on this process of finding other housing, other options. Why? So let me give you a little bit of format. We are also live on, I believe it's YouTube, possibly Facebook. This is being recorded, so please keep your comments. Remember that they are public at this point. We are National Real Estate Investors Association, and we want to reflect the ethics and standards that we hold to, even in our frustration. And I'll say it that way. With that, I've asked both Jeff Watson and Jeff Greenberger, I said attorneys par excellence, to join us on this. I don't know which of you wants to weigh in first and give a little bit of color commentary on this, as it were, and some insights. Leave it open to both of you.
I'm laughing because I completely agree with you. We have gone from unprecedented to crazy. What concerns me the most is this is now creating precedent for future administrations, future agencies to use this as a rationale to stop all sorts of economic commerce across the United States of America. Any particular form of commerce, any type of interaction, any type of business agreement, consumer agreement that they don't like, they can use this as a way of stopping it. And that is deeply disturbing to somebody who believes that we still live in a constitutional republic, or in the last vestiges of a constitutional republic, is what I'd like to think, given the fact that we still have a constitution, given the fact that we have a republic under a number of standards. I'll dive into the mechanics of this, but Charles, I want to piggyback off of one other comment you made, where if legal aid societies are saying this is the first day a tenant can sign that, I'm going to say the legal aid societies are not reading it correctly. There must be substantiated best efforts. And it's not good efforts, it's not some efforts, it's best efforts. And Jeff, I'm sure you're going to chime in with what you think about that, but I also think that means the tenant's got to open up their checkbook, their check register, their spending habits to the landlord to show how much is going out in non-discretionary spending, because that's a term used in this order from the CDC. What we have here, though, is this is going to get into a fact-by-fact quagmire that every court in every jurisdiction is going to handle it differently. And I'm shaking my head at the chaos that's going to ensue. Jeff, I'm going to let you make a couple of comments, and then I've got some more things I want to share. Is that fair?
Sure. I miss Zantac. I wish they would have taken it off the market. I don't care if it gives you cancer. I need it. I need it back. I miss Xanax. I miss Zantac. I miss everything. Look, the very short beginning of this is I need you to understand something. It's called a moratorium. It doesn't mean you can't file evictions against your tenants. What it does mean is your legal aid societies are going to set up peanut-style psychiatrist stands in front of every courtroom, and they're going to go to Sir Speedy, and they're going to print off these affidavits, and they're going to give them away or sell them for a nickel, and they're going to ask everyone going in, are you a tenant? They're going to give them to them or sell them to them, and they're going to say, sign it. And they're not going to tell people that there's the possibility they could go to prison if it's not accurate, which is true. And they're going to say, sign it. You don't have to leave. You don't have to pay your rent for the next at least 4 months, probably a year. All you have to do is sign this piece of paper, no harm. And that's all wrong, but that's what's going to happen. And the problem is that as soon as the tenant signs that piece of paper, and I'm oversimplifying it a little bit, the court has to stop the eviction. And if the tenant gives you that piece of paper anytime, what we're doing in my office right now is we're getting a letter out to our clients. And we're basically saying, we're going to start bugging you every step of the way in an eviction. When you send it to us, you're going to get this bounce back that says, have you been served with this affidavit under this act, whatever it's called, the moratorium, because the CDC is not exactly known for its legislative writings. I'll come back to that in a minute. And then before court, and then at court, I'm going to keep saying, have you been served? Have you been served? Have you been served? Because the problem is if you were served with this, we think today, and this might change, we think we can go through and have an eviction hearing, but we can't set them out. We think that's what the definition, the CDC definition of eviction is. It's the lockout. But if you're served with this and we file an eviction for you, which we're not going to do, you could go to jail. There are criminal penalties associated with this. There's also $200,000 fines associated with it, which I think, I see eyes opening up. You're actually looking at me. Hi. So, this is really serious. And so we're going to be asking a lot of questions. Your local attorneys should be asking you questions. Clerk of courts are probably going to look at you and go, are you crazy? You're filing an eviction. I just signed a couple evictions. We're going to file them on Tuesday. But it's only after I ask my clients, you sure? Have you been served with an affidavit? Do you want to? Do you understand the risks and the ramifications? And they're like, yeah, we're at this point, we've not been served. We don't think these tenants meet these qualifications. We've had no notice. I will also tell you, look, I know you're not all where I sit in Cincinnati, but we went to court this morning. It's day one of the moratorium, and we were allowed to cross-examine the tenant on their affidavit that legal aid gave them at a lemonade stand outside this morning. And the court said, yeah, you can cross-examine on the affidavit. It's just like what's called an informa pauperis affidavit, which is when they don't want to pay their other fees. And we won. The tenant could not support that they did what they were supposed to have done under the affidavit. The court said, I don't find your affidavit to be accurate. And they let us proceed and evicted the tenant.
Jeff, I need to interrupt you here. Did the court refer the
Oh, no.
for perjury?
No. And I've never won attorney's fees on an eviction case either. Yeah, no, I don't believe so. I
Because
didn't
that
actually.
affidavit was then made in bad faith.
What you need to understand today is it's a moratorium more in name only, but you have to be really careful and you have to understand what's going on. I'm sure Jeff will discuss more the mechanics of what you have to do under this affidavit. I'll leave those details for you to discuss if you want what has to be alleged. But you have to be really careful.
We both have to cover that. You and I are both going to have to cover that. Yeah.
Okay. And before you gentlemen go on with that, let me mention a couple of things here. There's a couple of questions on, and I will wade in way over my head here on the constitutionality of this because I've had a variety of attorneys chewing in my ear and chewing on my ear and giving me some different perspectives. And whether this could be qualified as a takings, I've heard from constitutional attorneys saying no, others saying only because it's an emergency, no. But even the justification for it, and this is the important part, is the reason it's Health and Human Services is doing this through the CDC. It's the emergency clause there. Folks, if COVID was a 35% mortality rate, we probably wouldn't be having this conversation. Yeah. So that's it. So this is where we're at with it. One of the solutions, and I want to put this out there for you guys, is to consider, is I've heard from some property owners already saying, maybe the solution, questions about this is an ongoing issue. And if I just rented to somebody and they started their first payment on September 1st and October 1st, they said, I can't pay. Here's my paper. Is it better to continue doing year-long leases or should they move to a month-to-month leasing process? And does that help get around? Because now you can say, I'm just not re-renting to you or I'm not renewing to you. Again, different counties, different states, there's different laws. So we want to be careful how we're weighing in on this, but that's been one of the suggestions brought forward.
Yeah.
In Ohio, I don't think it does you much good.
I'm making that suggestion, but I want to be really cautious because there are for-cause evictions in some places and not in others, in some states and some cities. The act itself, the CARES, because some of you are bound by the CARES Act, probably not many of you were prohibited from evicting under the CARES Act. The CARES Act still exists. So if you're under that moratorium, you're still under that moratorium too. And
don't forget the FHFA moratorium as well.
Right. Or if you're under Kentucky, you're still under Kentucky Governor Beshear's garbage, plus the new Supreme Court of Kentucky that came out.
Well, like I say, and Connecticut and Arizona.
Right.
California.
Not to mention California.
Came out with a new one last night in the middle of the night. The People's Republic of Massachusetts has theirs. So, yeah, there's all sorts of stuff everywhere. I want to be careful. There might be something to the idea of going month to month. I think the new moratorium might allow a little crack of light, but it's a state by state, city by city possibility. And I think it's a very slim crack of light. What I'm recommending to people, just my newest, bestest thing, is I'm recommending to people that you just sue people for rent, not for eviction. Just take them to small claims court and sue them for rent. There's no moratorium on suing people for rent. If they're working, then garnish their butts. First of all, you finally know where they are. You can get service on them, get a judgment against them, start taking money out of their pockets right now. At least they'll realize that there's some consequence to them not paying their rent, And they don't just get to sit there and keep going to Best Buy and buying bigger screen TVs. You're at least, they realize that you're not going to sit there and just, I can't think of a polite way of saying just take it from them. So that's as polite as I get. Excuse me to anyone I've offended by that. But some of my clients are actually hiring me now to just hourly sue these people. We're not evicting them. We're just saying you are now 4 months behind in rent and it continues to accrue. And on the day of judgment, we'll take a judgment against you. And in 3 months, we'll sue you again. In the meantime, if you're working anywhere, we're going to garnish you.
Or we're going to go after your bank accounts, because after the money hits a bank account, we can sweep.
And in that truck in the parking lot, that too.
Yep. You know? Yep. That is a great strategy. I never thought of that before, Jeff. I like it. I like it a lot. What I've been advising my followers, my listeners, my clients is being, number one, being proactive. Being very proactive with your tenants. I have maintained a lot of communication, much more than normal, with all of my tenants during this particular season. And if there's something wrong, I want to know about it. And so I've established a pattern of communication. And so I'm telling folks, establish a pattern of communication, because under that CDC moratorium, there's got to be communication. And if there's not bilateral communication, then that's a very big piece of evidence that you can do what you did earlier today, Jeff, and take one of those affidavits apart and have the court say, you know what, it's not true.
Jeff, I couldn't agree with you more. One thing that all my clients, both in self-storage and in multifamily or residential housing, have found is the millennials lose in this deal. We have to go back to actually talking to people. We can't be all online and virtual and log into the portal and pay. We are reaching out and talking. I heard a very interesting suggestion that I will not take credit for today that says it might be appropriate to start putting back into rental agreements that your failure to communicate with us when we reach out to you is an event of default. Because this is going to come up. If they're going to use this against us now, whoever, Charles or Jeff, whichever one of you said it, it's going to get used against us in 2 or 3 years again. Someone's going to pull this moratorium out again in a year or two for some other reason. And they're going to use this same, you got to talk to your tenants. I remember when Eddie Murphy used to play Mr. Robinson, right? And when he didn't want to talk to the landlord, he jumped out the window. One of these aspects of this affidavit that, you know, we have to have had a chance to talk to our tenants. We have to have tried to work it out with them. So if you're Mr. Robinson and you just keep jumping out the window, we can't evict you. So now maybe we have to have something that says we tried, and it was in, you know, provision 72 of your lease says if we reach out to you 3 times and we try to talk to you and we keep catching you jumping out your window, that's a non-monetary default.
Yep. And going back to your comment about millennials, I've learned to communicate with my millennial tenants the way they want to be communicated with.
Standing under the window?
And that's text messages.
No.
Text messages, because I can screenshot it and I've got a record of it. Or emails, things like that, because then I can go, here's my screenshots of the 6 text messages over a 4-week period of time going, what's going on? Talk to me. How can I help you? And just last week, we had a tenant come in and go, hey, I changed jobs. This is what's going on. We work with them. We've got a track record. I've got a paper file out the wazoo of how we work with tenants. And folks, this is going to be a test of how well do you do your business of being a landlord. Yes, it's getting infinitely harder. But you've got an above average education. You've got a vested interest. You've got communication skills. You understand why every word in that lease is there. You need to be using it. You need to be proactive. You need to be working with your tenants. You need to be showing an example of how actually this works. And hopefully you've been doing a good job screening your tenants all along and you're moving along. So we'll go from, I'm ready to shift a little gears here. Okay.
Let me say one other thing real quickly. As a practicing attorney, lots of my clients come into court with me and say, I've got text messages, and they try to show me their phone. If you don't want your phone held as evidence in the court files for the next 2 years, you need to bring those printed out, multiple copies, if you want those entered into evidence. Otherwise, I have to
Amen.
have your phone seized and entered into evidence. So please don't do that to me or your own attorney.
All right. So this, and by the way, folks, this CDC moratorium applies only to tenants who are not paying rent, who are being evicted for non-payment of rent. If they're a bad actor, in other terms, if they have breached the rental agreement in other ways, you can go through the regular process under the CDC moratorium and move for their eviction. It will take longer. You'll have to do the proper notice procedures as your state has, but that's different than what what may be construed under the FHFA or under the CARES Act moratorium as well. So you've got to know under which ones you follow, and that's an all-day process sometimes to figure out which ones apply to you, which ones don't.
I'm going to say along those lines, Jeff, and thank you for clarifying that. Even I just have in my hands, the Ohio Supreme Court came out with a ruling today, and their last statement is evictions still may be filed for reasons other than non-payment of rent. And you're going to see this is pretty much standard across the board, but that's the kind of thing to keep in mind. There are still venues, but it depends on somebody. Are they violating their lease or not? Mr. Greenberg and I just had a little exchange the other day, and he said, "You mean your tenants don't violate their lease?" I actually jokingly referred back and said, actually, most of these ones don't. They actually pretty much comply, which is fantastic. They also pay the rent for the most part. So good screening does help. A little, shout out to some of our screening people.
Earlier today, I was privy to see a quick little slide deck that came from the judge in Lakewood, Ohio. Lakewood, Ohio is part of Cuyahoga County. Lakewood is probably one of the most dense populated areas in the United States between New York City and Chicago, Illinois. Huge amount of rental property there. And this judge has already analyzed the CDC moratorium, and he's basically saying he will hold evidentiary hearings on the validity of those affidavits. Just like what Jeff talked about having happened this morning in court. And folks, this is where you've got to be building your evidence before you contact your eviction lawyer, after you're working with your eviction lawyer, all the way up to walking into the courthouse.
So I got a couple of questions. I don't know if you want to touch on some more of the specifics of this, or we can go into a couple of questions here.
I'm ready for a question or two.
Okay. One of them was going back to that issue, and I'm just going to reiterate this. Instead of doing year-long leases, should we start looking at month-to-month and just addressing it that way as one side of it? And I think the answer that you gave was it depends on your state and what your local laws are. So again, folks, we're not trying to be, evasive, but with 50 states out there, some people are asking questions. I'm asking, which state are you in? Because it does matter. And I want to try to give our attorneys at least a couple minutes to answer and staying on focus and on task with this issue with the CDC at this time. There's a question that came about regarding non-payment versus eviction for foreclosure and such. And I would suggest to you that foreclosure is a little bit outside of what we're looking at right here. We will see about getting an answer on that. So John, I saw your question in there. We do want to get an answer for you, but probably not appropriate here just because we haven't even given these guys a chance to look at the foreclosure side of things. And that actually falls more under FHFA and the rules following that. So how broadly that actually impacts. The CDC ruling we're talking about is specifically to evictions and evictions, not foreclosures. I'll qualify it that way. How about one of the questions that came up is if somebody is responsible for their rent, which is what the CDC still says, what should I do? The CDC instructions say that they're actually to make payments to the best of their ability up to the full amount of the rent. Do you guys have recommendations on ways that should be put together? Or workouts should be handled, or agreements should be handled?
I believe you do need to do a written agreement, clear, and I've got a sample version of it, and Charles, I'll make it available to you and to Lori so that it can circulate out to anybody and everybody that wants it. And it's something I actually collaborated with my friend Mark Dan who former Ohio Attorney General. He's on the other side of a lot of things that I am politically and legally, but we're good friends. You need to put it in writing. And I think the phrase that I want everybody to talk about is this. It goes back to best efforts. The tenant has to show you that they're making their best efforts. So if they're down to Best Buy buying another big screen TV, that's non-discretionary spending. I'm sorry. That's not going to work. They're going to have to show you their spending habits for the month that they're not paying rent. If they've got money going to gas, electric, water, groceries, great, fine. Medical, okay. If it's Netflix and Hulu and Disney Plus and Amazon Prime and all this other stuff, I'm going to be like, no, that's discretionary. You've got to show me what you have available and how much of that are you putting towards your rent. So it's a conversation that requires, in my opinion, for the tenant to open up their bank record and let you see what they're doing.
I think we've tiptoed around it. Let me give you the list of what this affidavit is expected, or what the order says the affidavit is supposed to say. Okay? Now, obviously, these don't all apply in each case, but let me just, if you don't mind, I hate reading things on these things, but let me read you. This is, I am supposed to certify under the penalty of perjury that the following are true and correct. Jeff, just chime in on each one of these. It gives you a heart palpitation. Okay? I have used best efforts to obtain all available government assistance for rent or housing. Okay? That's why Charles and Jeff were talking this morning about you can't just sign this morning.
Where are all the where's a copy of all the applications you've submitted for that kind of assistance?
Okay. By the way, one of the notes in the actual language of this bill says that every person in the household has to sign one of these. So I am at a complete loss of what I'm supposed to do if I've got 3 people living in a house and I get one affidavit.
I'm lost too, Jeff.
Are we back to an et al?
Are we back to
Well,
evicting
can I evict 2 of them and then decide what to do when it comes to lockout time?
Yeah.
I'm just curious. I either expect, not earn, I expect to earn no more than $99,000 in annual income for calendar year 2020, or no more than $198,000 if filing a joint tax return. Was not required to report any income in 2019 to the U.S. Internal Revenue Service, or received an economic impact payment stimulus check pursuant to Section 2201 of the CARES Act. This is the one that blows me away, right? Because I keep reading this, and every time I read it changes, I change my mind about this. Am I not entitled to the moratorium if I received that $600 a week stimulus extra unemployment benefit? Because that's a million people that is now no longer entitled, or millions of people that are now, every time I read it, I switch. I'm like, yes, then no, and then yes, and then no.
I read it as that they were eligible for and did receive their $1,200 stimulus check. Not unemployment, but their one-time stimulus check. If they got it, or if they make less than $99,000 or less than $198,000 as a family. That's how I read it.
So if they got it, then the moratorium.
Then then they can be covered by the moratorium.
So no matter what. Okay. A lot of attorneys on the last call that I was on are interpreting it that if they got the stimulus, they're excluded from the moratorium.
I read it that way the first time, and I shook my head and I said, no, that can't be. So I went back and read it again, and that's why I came up with
it again tonight after a bourbon, and let me know what you think.
So what you're saying is, if you ask 2 attorneys what their opinion is, you'll probably get 3 answers.
3 answers.
Yeah.
And
Okay.
after a bourbon, 4
or more.
Okay. Here's the one. Here's the one that's going to make Jeff watch Jeff's eyes. All right. I am unable to pay my full rent or make my full housing payment due to substantial loss of household income, loss of compensable hours of work or wages, layoff, or extraordinary out-of-pocket medical expenses. That's the one where he wants you to open up and show me. But here's the one. I'm using best efforts to make timely partial payments that are as close to full payments as the individual circumstances may permit, taking into account other non-discretionary expenses. Now that blows me away, because if they're not paying you anything, I get the right to cross-examine you and say, where's my partial payment?
I'm going to back you up, Jeff. I want to talk about what is a substantial loss of income. I want to know what is an extraordinary out-of-pocket medical expense. It's got to exceed 7.5% of the adjusted gross income for that particular year.
If you're using the IRS definition, because I'm never allowed to deduct out-of-pocket medical expenses. I don't know.
So I'm like, what's a substantial loss? If you're telling me that you're missing a day or two a month, I'm sorry, that's not substantial. But if your hours have been cut to 1 day a week, okay, then I'll.
But if you're not, but if legal aid's telling people don't pay your rent and come into court,
can you sue legal aid for malpractice?
Where we are here, we have a lot of attorneys that file motions for sanctions against legal aid every time, so that they have to report it to their carrier. They don't expect you to get them, but they love that they have to report to their carrier. But I just want you to all understand, at least as we read it here on day one, if they're not paying you anything, I think that's challengeable. Now, you got to get to court, and that runs risk. Because if you file this eviction and you've been served with this affidavit, there's a judge that could say, excuse me, you were served with this affidavit. How are you in my courtroom?
Your Honor, I'm here on a motion to strike the affidavit that I filed once I received it.
But you have to get in front of court first, so that means you had to file the eviction, which puts you in peril of jail or a $200,000 fine.
If you get the affidavit before you get to the courthouse and get your case number, you got a problem.
You are
get your
screwed.
Case number before you get your affidavit,
Yes.
Then you can file your motion to strike the affidavit.
That. I know. Okay.
We're racing to the courthouse again, Jeff.
Yeah, I know. I'm going to have to start wearing track shoes okay. If evicted, I would likely become homeless or need to move into a homeless shelter or move in with my in-laws. No, or need to move into a new residence shared by other people that I find repulsive. No, and live in close quarters.
Yep.
I have no other available housing options. And then they're going to say, I understand that I still must pay rent or make a housing payment and comply with other obligations. That I understand that my tenancy lease agreement or similar, that I may have under my tenancy lease agreement or similar contract. I further understand that fees, penalties, or interest for not paying rent or making a housing payment on time as required by my tenancy lease agreement or similar contract may still be charged or collected. I want to be very careful. They're signing that in the affidavit. Your state may not allow that still. So just because it says it here in the affidavit, you may not be able to charge it. Like in Kentucky, we're under an executive order not to charge late fees.
Now, on this section here, Jeff, there's something here that I saw that was language unique to the CDC, where I paraphrase it as, because of an eviction, would likely be rendered homeless or forced to move in with and live in close quarters with a new congregate or in a shared living setting. Okay, I'm going to emphasize the word new. You mean you're going to have to go live with people that you've so far been socially distancing from? Because if you've not been socially distancing from them, they're not new to you. You've been congregating with them in the past. But you see where I'm nitpicking on this thing?
Finally, I further understand that at the end of this temporary hold on evictions on December 31st, 2020, my housing provider may require payment in full for all payments not made prior to and during the temporary halt, and failure to make payment or failure to pay may make me subject to eviction pursuant to state and local laws. Yeah, it's called the cliff. And then we'll hear the New York Times bitching about the cliff that this law created. So I don't know. That's what the affidavits are going to say that you're going to, theoretically, that you're going to be served with. That's what Jeff and I want you to be ready. If you want to try to file an eviction and you can beat that affidavit to court, what Jeff and I are saying to you is at this moment, and of course, always work with your own attorney. And of course, this presumes you're not under some other eviction ban like California, Massachusetts, where you couldn't even file right now, Florida, I think.
Or even as was brought up, Jeff, in Illinois, where the discussion, as Jane Garvey has mentioned, that they're actually, this actually is better for them than what Illinois actually has. So, you know, and folks, we're going to find that across the 50 states. Some people go, well, this is better than what we had. Other people are going, are you kidding me? This is horrible. That's the problem with one size fits all.
Yeah, and I have successfully done one eviction since the COVID outbreak. One. And
Wow.
it was moving heaven and earth to get it done, including move out.
Down here a lot. So
including lockout and move out. Yeah.
Anyway, my point is, I think Jeff's point is, work with your local attorney to see if you can even do evictions. If you can, we think you shouldn't be doing them if you're served with this affidavit by your tenant before you get the file stamp, you know, get the eviction to the courthouse. But if you get to the courthouse and then they try to serve this on you, you better be prepared to fight the affidavit. We think what's going to happen, at least down here, what we're being told is going to happen. And look, every county's different. We've heard in one county, the judges aren't even going to honor these things. We have a county down here where the judges have basically, they're like, the federal government does not have the standing to do it. And we're not even listening. Just bring your evictions. We'll deal with it. Okay. But where we sit in Cincinnati, what they're going to do is they're going to give a hearing to every one of these. Thank you, David. They're going to give a hearing to every affidavit. It's better than what they were talking about doing, which is continuing every eviction flat out and giving the judges another paid vacation. So you're, depending on where you are, you may have a hearing, and you better be prepared to ask about, what have you spent your money on this month? How much are you bringing in? Where did it go? As Jeff said, bring me receipts.
Yep.
If you don't have receipts, let's continue it 3 days. Show me your gas bill. Show me your water bill. Show me I'm your landlord. I know what the average gas bill on this house is.
So I'm gonna pull this back up to a high level for a second, folks. If you haven't figured this out yet, this is not the time to be doing your own evictions.
Oh yeah.
It is mandatory for your survival at the peril of what I think Jeff said earlier, a $200,000 penalty or fine. It is mandatory for your survival.
Let me expand on that, Jeff. And just to be clear for everyone, this is what the law actually says, okay? And I hesitate to do this, but I'm going to read it verbatim here just so you understand what is at risk. And think about the terms of this to your bank account. And then I'm going to go to more of a little wrap up here with a couple things I'm going to tell you, okay? A person violating this order may be subject to a fine of no more than $100,000 if the violation does not result in a death, or 1 year in jail, or both. A fine of no more than $250,000 if the violation results in a death, or 1 year in jail, or both, as otherwise provided by the law. Additionally, any organization involved can be up to $200,000 if death is not involved. If there is a death, it can be up to $500,000. So if you have an LLC, it might be you and your wife. At that situation, guess what? You could both be in jail for up to a year, paying up to $100,000 in fines. And since it just says death, if they left and they moved to an area where they walked down the street and got killed, that might be the death that could have been avoided if they'd have been staying in their place. That could be $200,000 for each of you, a year in jail for each of you, and then your LLC charged up to $500,000. So I want to impress upon you the seriousness of which this can be, that this could amount to huge amounts. And that doesn't matter whether you have a 2-family or 2,000 units. Okay, that doesn't matter. It's, did you violate this section of the law? So let me take a positive piece on this for a moment and just focus on what we can do. One, we shared out a voter voice. Lori posted up the action in our action area, our action center. Something you can do, folks, share this out with as many people as possible. Post it on Facebook, get people to go to this link, send responses in. That is how we're going to, when local congressmen and senators are calling up HHS, they're calling the vice president, they're calling the president, they're getting the interest going, why are we doing this? Why are we doing a uniform ban across the country? That will put pressure on to relieve this and start laying the groundwork politically for the legal response. Okay, and that way, this is the political, you have to do the PR side. And let me be blunt, the other PR side that needs to be addressed, folks, if you're doing workouts with people, make sure you're sharing that with the leaders at your local association so that when they are asked by the media, hey, what's going on in this area? How are you doing? You've got some answers to say, hey, we've got workouts. Now, I might redact it out so it doesn't have somebody's name on it, but I can say, look, here's examples of workouts. This couple is working with this couple, that this people, they only have a 6-unit building, but you know what? They've got 2 people that they're doing workouts. And this nurse has been working overtime, but then she was cut back on time and now she's called back. So they're working through those are good stories that we want to make sure are being told. If you're not telling those stories or you don't have those stories ready, you are going to get blasted. So please have those ready. And finally, please, one of the things that we've also shared out here, Lori, if you reshare the breakdown as well, there's a link to, this is a National Apartment Association. You put this out and we've been sharing it and utilizing it as well. This is a breakdown of the average rents across the country. 39 cents actually goes towards mortgage. About 10 cents goes towards capital improvements. 27 cents of every dollar goes to employees, utilities, insurance. 14 cents goes to property taxes, making sure that the roads are paved, the schools are open. And somewhere under 9 cents possibly goes to profit if the units are fully occupied and you're functioning, okay? We've been sharing that out. We want you to use that as well. It's our sister organization, and this is one of those things that you can say, look, this is not some rich person making buku bucks. This is a very small margin business, and folks, you share that, it becomes very obvious, and reporters will pick up on it. It's a good graphic. Use that. This may be able to resolve, but we have to have a response that addresses this side of it from a PR perspective, even as the constitutional lawyers are preparing to address that side of it. I would love to say that, and I'll let the attorneys reflect on this, but I would love to say that law just by itself moves forward. But if the judges are not feeling the pressure and they're not hearing the pressure, they're not as likely to act as if they've got congressmen, senators, the president, the vice president going, wait a second, this is getting a whole lot of grief. So, or causing a bunch of grief, then they're a little more likely to act. So with that, I won't ask you two to weigh in on how the judges are going to do that, but folks, we've got to do our side to it. And that means having both
I'm going to use the word optics, Charles. I'm going to use the word optics. I hate to admit it, but Lady Justice standing there blindfolded with the scale in one hand, I'm sorry, that blindfold has now been dropped down around the chin. And they care about optics. And so your advice, your encouragement on creating good optics is necessary for our survival. Because if landlords can consistently be seen as decent human beings who are doing the right thing and helping people, man, we can dispel this snively whiplash aura that still clings to us.
Yeah, that's exactly it. We're coming up on 148. I don't want to belabor this. Folks, this is going to be a developing situation. I would expect there to be some lawsuits coming from across the country on it. Even as we said when we first started these kind of meetings with COVID back in March, we will be out to you. We're trying to keep you updated as soon as we find out something. If we hear something, we'll be back on this. Look for updates. In the meantime, please go to Voter Voice, reach out to folks. I'll ask Jeff Watson first and Jeff Greenberger for some final comments and some encouragements here. Mr. Watson?
Number one, know your business. Number two, communicate with your tenants. Number three, use Voter Voice and share your wins. That'd be the fourth thing, is share your wins. Charles, I'm going to go ahead and put out on social media the rent modification we negotiated earlier this week with a single mom, just to give her a break because of a change of job due to COVID. We're just going to do it. And yeah, I want to got to create the positive message out there.
And I have the gathering of that. One thing, I don't mean to be a little Debbie Downer on this, but if for any reason you find yourself ensnared in these things, please let somebody at RIA know. Because the one thing we cannot have happen is we got to let the big time professional constitutional law lawyers handle this case. So please, if you find that somehow you are getting dragged into one of these things, let RIA know so someone can help you and get you in touch with Jeff or someone on legal at RIA to help.
Because you're so right. You're so right, Jeff and Charles. This has got to be done with the right fact pattern. Got to have the right fact pattern, and you've got to have it done in the right, where you can draw the right district court and the right court of appeals.
Yeah,
you got to think about the court of appeals, because you can get you there, and after that, it's who knows.
I go back to something we said back in March. Even don't be that guy. And the example we gave of that guy was the situation where right after COVID and right after all the lockdowns started, he sent out an email. I expect all my tenants to pay the rent, blah, blah, blah. You will be evicted, blah, blah, blah. And literally within a 24-hour period, he's, I'm out. I'm sorry. I'm flexible on anything. I'm no longer even managing my own property. He was backpedaling so fast. It was like, don't be that guy. Use good common sense. Focus on this, folks. And I'm going to come back with a final question that was asked. I think it's actually really relevant right now, which is, somebody's got a vacant unit. Do they move forward with putting somebody in there? As Rebecca pointed out, screening is absolutely critical. We have some great screening partners. I won't go into details right now, but Rebecca, maybe we have them on at the next update and just touch on some things that they can do to find out, from evictions to making sure that people really are saying what they have as far as credit and such as well, not just the criminal side of things. But
can I ask the attorneys one quick question on this topic before we leave? Would it be appropriate right now for new leases, and can we do it without fear of fair housing violations, to bump up our minimum requirements, specifically on credit score, hoping that those with a really good credit score and that have been super responsible to this point would not want to later endanger that with the possibility of a small claims court action showing up against them? Could we, during this process for new rents, move up our standards on our lease agreements?
It's always been my understanding that as long as you're not doing it just to address one individual applicant, you may change your rental standards. I don't want to say on a daily basis, but if you want to change your rental standards going forward for a period of time, you can move them up, you can move them down, but you can't do it just to say, he's a great guy, so I'm going to move my rental standards to make it work for him or to make it work for her. But if you want to say this house is now minimum credit score, or this building's minimum credit and criminal score, this aggregate screening score is now going up to X, and it's effective the morning of this, and that's how we're going to run it for at least the foreseeable future, that is something you can do as long as it's published and known.
And I would call it enhanced economic underwriting or modified economic underwriting, that you're changing your underwriting standards solely from an economic perspective. Not just, and I would say I'd look at more than credit score. I'd look at employment history. I'd look at how long are they at this job? What kind of a job is it? How vulnerable is that particular occupation? And go from there. That's how I do it. But you've got to be consistent and uniform.
we got some good answers coming in from around the horn, as it were, from folks. So pay attention to that. Again, part of National RIA's strength is we've got a lot of experts out there, and folks in your community, make sure you're working with your leadership, working with your association, share this information. As we get more information, we will be getting this out to you. I don't want to go too long here. We're at 1:55. We said an hour. Folks, we want to keep you updated, and as there are developments on this, we'll be back to you. This isn't the only issue that's out there, but there's probably going to be more coming. Let's see what we can do to make sure we're moving past it, we're protected, and make sure our association members are taken care of. With that, we're going to wrap up here, and I appreciate you guys coming out today. Mr. Watson, Mr. Greenberg, thank you guys for your insights and some very relevant facts coming back to this. Thank you. We'll stay on a positive note. We're going to update you as things come forward. We look forward to catching up with everybody. Thank you very much.
Thank you. Peace.